Vidit, I will add. Good evening to all of you, those who are watching us in India. If you are in Europe, it is good afternoon and good morning to people in the United States. On behalf of O.P. Jindal Global University and Jindal Global Law School and the Embassy of India at The Hague, I would like to extend a warm welcome to all of you to this webinar series on contemporary reflections on international law on the theme Indian Judges and the International Court of Justice. My name is RajKumar. I'm the founding Vice Chancellor of O.P. Jindal Global University and Dean of Jindal Global Law School. I have with me three outstanding individuals who will be discussing today about this theme. Let me at the outset welcome Mr. Philippe Couvreur, the former Registrar of the International Court of Justice, Professor B.S. Chimni, Distinguished Professor of International Law of Jindal Global Law School at O.P. Jindal Global University, and of course our collaborator and co-host, His Excellency Mr. Rajamony, the Ambassador of India to the Netherlands at The Hague. Let me invite the Ambassador of India to Netherlands, His Excellency Mr. Rajamony, to begin this session. Ambassador Rajamony.
Thank you, Dr. RajKumar. Good evening, everyone in India. Good afternoon for those in Europe, and good morning for those in the US. It's truly a pleasure to have such a global audience for this wonderful webinar. And I begin by welcoming each and every one of you to this session, which I promise will be both interesting as well as highly enriching. Let me begin by explaining that this joint initiative between the Indian Embassy and the O.P. Jindal University is a series of webinars which we have titled Contemporary Reflections on International Law. The purpose of this series of webinars is to try and bring the best of legal minds, the leaders of intellectual law who are available here in The Hague to audiences in India as well as other parts of the world, and equally to also showcase the wonderful legal talent that we have within the country. This particular seminar, the first of its kind, is titled Indian Judges and International Court of Justice. But let me straight away also mention that we have the second webinar already planned for the 19th of October this year at the same time, in which we will have the President of the International Court of Justice, the Registrar, and Judge Bhandari from the International Court of Justice participating on the theme of international judicial process during COVID-19. COVID-19 is a challenge which the whole world is confronting now, whole world is grappling with and trying to deal to the best of its ability. But in a way, challenges bring opportunities, and the opportunity we have here, as I already explained, is to bring people who otherwise may not have the time to travel to India to attend a program through these modern technology and online means, and to have an interactive experience of a kind which has not happened before. Why do we want to bring The Hague? What is special about The Hague? Let me briefly mention for those who do not know. The Hague is home to the International Court of Justice, where Mr. Couvrer has worked long years. He was Registrar of the International Court of Justice. The Hague is also home to the Permanent Court of Arbitration. The Peace Palace building hosts both the Permanent Court of Arbitration and the International Court of Justice. It is also home to the Hague Academy and one of the best law libraries in the world, which is located as part of these legal institutions. Hague is home to the International Criminal Court. It is also home to the Hague Conference on Private International Law and a number of other institutions dealing with international law. The people of the Netherlands describe The Hague as the city of peace and justice for its long association with international law. Hugo Grotius, considered the father of international law, was a Dutchman. In fact, he shot to fame. The major work that he did on the law of the sea was done defending the Dutch East India Company when one of its ships privateered and took over a Portuguese ship. Hague was host to the Hague Peace Conferences of 1899 and 1907, which were the first exercises to try and create an international jurisdiction and to establish basic principles of disarmament. It is during the second peace conference of 1907 that it was decided to establish the Permanent Court of Arbitration, and subsequently the Peace Palace was created with funding from Andrew Carnegie to house the Permanent Court of Arbitration. In 1907, the foundation stone for the Peace Palace was laid. 1913, the Permanent Court of Arbitration started functioning there. And in 1922, the Permanent Court of International Justice under the League of Nations started functioning there, which continued till 1946 and the establishment of the International Court of Justice. Friends, we in India have always upheld the highest respect for international law. The Indian Constitution itself, in Article 51, the Directive Principles, mandates upon the state to promote international peace and security, maintain just and honorable relations between nations, and to foster respect for international law and treaty obligations in dealings of organized peoples with one another, and also to encourage settlement of international disputes through arbitration. In the famous case of Keshavananda Bharati versus State of Kerala in 1973, the Supreme Court, Chief Justice Sikri, observed, "It seems to me that in view of Article 51 of the Directive Principles, this court must interpret the language of the Constitution, the Indian Constitution, if not intractable." And he describes the Indian Constitution, interestingly, as a municipal law. He says, if not intractable, which is after all a municipal law, in the light of the United Nations Charter and the solemn declaration subscribed to by India. This shows the importance that the Supreme Court of India has itself attached to the UN Charter, to the principles of the UN Charter, and in logical conclusion, the ICJ and all its judgments, all its pronouncements play an extremely important role in India's approach towards international law, in India's approach towards global relations and the world community. We believe the ICJ has a very important role to play in the interpretation of and clarification of the rules and principles of international law, as well as in the progressive development and codification of international law. The International Court of Justice has had a very interesting history, and I'm sure this is something which will come up in the course of today's discussions. From 1951, we have had 4 judges elected as judges to the World Court and 3 judges ad hoc. Again, the details will come up. Let me just mention the fact that one of the principal criteria for the election of judges to the International Court of Justice is geographical representation, as well as representation of principal legal systems of the world. We in India believe that with 1.3 billion people, 17.7% of the world population, we should have a place in the International Court of Justice. The Indian legal system as a whole has much to contribute to the development of international law, as well as to learn through the cross-pollination which happens in institutions like International Court of Justice. So there has been in international politics a conventional belief that all UN Security Council members should be permanently on the International Court of Justice, but other countries can take turns as and when it is possible to include them. I think we in India do not believe in that theory. In fact, the last elections when Judge Bandari was elected to the International Court of Justice was an example where a member of the UN Security Council had to give way to the Indian candidate. And we hope in the coming years, as one of the most important legal systems of the world, as a system which represents one of the largest countries in the world, the second largest country and soon to be the largest country, India should always have a place in the bench of the International Court of Justice. With these few words, let me go to my task of introducing our panelists today. I begin with Philippe Couvreur, who's a personal friend and a great friend of India, who has known India very well, and he has known personally most of our judges who have sat on the International Court of Justice. He will speak from his personal recollections. He has altogether served 37 years in the International Court of Justice. We cannot think of anyone who knows the court better than him. He was registrar from 2000 to 2019. Mr. Couvrer has actively participated in the handling of over 90 cases and advisory proceedings. And along with his career in the International Court of Justice, a very busy job, I assure you, he has also been an academic. He has been teaching at the Leuven University of Belgium, as well as many other universities. And since his retirement in 2019, he has also served as a judge ad hoc at the International Court of Justice. Mr. Couvrer, it's my great pleasure to introduce you and to welcome you to this discussion. Thank you so much for having agreed to participate in this. The second panelist I'd like to introduce is Professor B.S. Chimni, whom I'm very happy to acknowledge is a very distinguished senior of mine from the School of International Studies of JNU. Professor Chimni is now Distinguished Professor of International Law at the Jindal Global Law School and an expert in international law, international trade law, and international refugee law. He has been with JNU for long years. He was Vice Chancellor of West Bengal National University for Juridical Sciences. He has been at Tokyo University. He has been a visiting professor at he has been a Fulbright professor at Harvard Law School. He has been at the Max Planck Institute in Heidelberg and at York University in Canada. But most important of all, I think he is part of a very interesting group of scholars who identify themselves as the third world approaches to international law. And this is a critical school of international legal scholarship, an intellectual and political movement, which tries to present a broad dialectic in opposition to international law. It believes that international law in many ways is a colonial creation, and it continues to facilitate exploitation of the third world through subordination to Western ideas. This again is a very interesting topic. I'll be very keen to hear what his views are on Indian judges and their contribution, and it'll be a very interesting contrast from Mr. Couvrer's views, I'm sure. But let me say that in general, a refrain that is constantly heard is that there is a Western domination over the practice of international law, and that should change. There should be more and more participation by lawyers and judges from India. And this is a collective endeavor that we in the embassy and the government of India have been supporting in whatever manner possible, and we would like to take it forward. Finally, I come to the moderator of this evening, our co-host, my good friend, Dr. C. RajKumar, who I best describe as a wonderful bundle of energy, charm, and scholarship. He was he at the young age of 34 became the founding Vice Chancellor of O.P. Jindal Global University, which is one of India's youngest universities, but amongst the best of the young universities in India. It has been ranked #1 private university in India. It is #1 university in social sciences and arts and humanities. Its law school is nominated #1. It has also been nominated as the best liberal arts school in India. And it recently became in the top schools, top young universities of the world, a listing created by DS Young University Rankings in 2021. Dr. RajKumar again has been studying and acquiring degrees in various institutions across the world. He has been part of University of Oxford, Harvard University, University of Hong Kong, University of Delhi, and Loyola College, where he started his initial education. His areas of specialization are human rights and development, terrorism and national security, corruption and governance, law and disaster management. He is also an expert in higher education. And it is amazing that he, along with his very heavy responsibilities as Vice Chancellor, over the years, he has produced 175 publications, including 7 books, all of which have been reviewed and acclaimed in journals and reviews across the world. With these words, I conclude my opening remarks. I'm delighted to launch this series of webinars. Thank you so much, Dr. RajKumar. O.P. Jindal and the entire team for joining us in this effort, and we look forward to continuing to work closely with you in this regard. Thank you. Good evening, everyone.
Thank you very much, Ambassador Rajamony, for a wonderful introduction. I must, of course, take this opportunity to formally introduce His Excellency Mr. Venu Rajamony, who is a career diplomat with over 3 decades of experience. Mr. Rajamony is the Ambassador of India to the Netherlands since June 2017. He is also the permanent representative of India to the Organization for Prohibition of Chemical Weapons at The Hague, as well as responsible for India's relations with the International Court of Justice and the Permanent Court of Arbitration. Ambassador Rajamony appeared on behalf of India before the ICJ in the matter of, quote, advisory opinion concerning the legal consequences of the separation of the Chagos Archipelago from Mauritius, unquote. Ambassador Rajamony held the prestigious office of the Press Secretary President of India during the tenure of President Pranab Mukherjee from 2012 to 2017. I'm also deeply appreciative of the contribution of the Indian Embassy at the Netherlands for forging strong collaborations and partnerships with universities, academic institutions in India and Netherlands in general, but also in particular today's program as well. Thank you, Ambassador Rajamony, for your presence and participation. Let me move to the substantive part of today's program. Now, of course, the topic of today's discussion is Indian judges and the International Court of Justice. Now, there is an element of ethnographic dimension, which I'm sure Philippe will talk about it. There's also a substantive aspect of what the contribution of the Indian judges and indeed the International Court of Justice as an institution is concerned. I think it is only fair to say, and as Ambassador Rajamony underscored this element, that India and Indian judiciary has been advancing the cause of international justice in all its forms and manifestations, and Indian courts, unlike many courts around the world, didn't to a large extent hesitate to use international law, international human rights law when it comes to determining domestic application of legal matters. It has invoked the Indian Constitution, but also invoked many aspects of international treaties, international conventions, international declarations, and this is not uncommon for the Supreme Court of India in particular to invoke it to even strengthen Indian jurisprudence. To that extent, the use of international law and use of international justice elements within the context of domestic adjudication is something that we have seen a lot. So today, we're very delighted to have 2 distinguished individuals talk about the evolution of Indian judges and the International Court of Justice. I'm going to ask, the first thing I will ask both of you is to briefly reflect on the theme and indeed the broader focus of the theme, and then we'll go into some of the more specific questions. So let me start with Philippe for you to reflect on the theme. Philippe, can you unmute yourself, please?
Is it okay now?
Yes, it is.
Yeah. Thank you very much. First of all, good evening, good afternoon, and good morning to everybody. I would like, first of all, to thank again the Indian Embassy in The Hague and my very good friend, Ambassador Rajamony, also for his good words, kind words, and Jindal Global Law School and Professor RajKumar for the kind invitation to participate in this very interesting seminar about Indian judges of the ICJ. It's an honor for me to be associated to this important meeting, and it is certainly a great pleasure because the ambassador reminded that I've been almost 40 years at the court, and so I had the great privilege to know personally 3 of the 4 permanent judges from India and 2 of the 3 ad hoc judges of India at the court. I think that the theme of this webinar is extremely interesting because we will have to go rather frequently beyond the strict legal aspects of the activities of those judges. I think we will find that their personalities, their personal backgrounds, their Indian culture and beliefs has been very present throughout their mandates at the court. And I think the court benefited quite a lot from that. The court is very indebted with them, not only for their legal input again, but for more than that, for their personalities, for their style, for what they brought beyond law, culturally and spiritually to the court. And probably I won't say more than that at this stage, because I intend to go into more details in that, but following the questions you will ask us. And I think it's better not it's better to avoid repetitions, and therefore I'll stop here. Thank you again.
Thank you very much, Philip. Now I invite Professor Chimni to briefly reflect on the broader theme of today's discussion, after which I will outline some of the broad contours of the discussion as well. Professor Chimni.
Thank you, Professor Rajkumar, for giving me the floor. At the outset, I would like to congratulate the Indian Embassy in Netherlands and Jindal Global University for this very, very important initiative to conduct a series of webinars to reflect on contemporary international law and India's role in its development. And congratulations in particular for today's webinar, which seeks to acknowledge the contribution of Indian judges to the International Court of Justice. And thank you, of course, for inviting me to be part of this panel. It's a great privilege and honor. Now, what I had proposed to do was to reflect on two questions. Maybe I can reflect on the first question first and come in later speaking to the second question. I think in terms of acknowledging the role of Indian judges, whose name were mentioned by Ambassador Rajamony in his opening remarks, 4 permanent judges and 3 ad hoc judges. It is very important to understand the considerations which need to be taken into account to appreciate their role. And I wanted to very briefly touch on at least 2 important considerations that we need to bear in mind in terms of appreciating the role of Indian judges. The first is that one usually tends to look at the role or determine the role of a judge on the International Court of Justice by looking at their separate opinions or dissenting opinions, because these carry their names. And therefore, it's usual to look at these judgments, their separate opinions or dissenting opinions, to determine their views on international law and clarifying its role. But it's equally important to understand the role that individual judges play in the internal discourse, or in the internal discourse of the court, or in the internal deliberations of the court. So if you are a judge who goes along with the majority opinion, your name may not appear in terms of a separate opinion that you have delivered, but you may have played a very critical role in shaping the opinion of the court. The internal deliberations are in several stages, but which includes each individual judges after the oral and written hearings to write their own notes, then deliberate these with the other judges, And then there is, of course, the drafting committee. Then there is an early draft. There are first readings, second readings. So there is a long process before the court announces its judgment. And unfortunately, because this is confidential, it is not possible to know what role each individual judges have played in the process. But it's very important to bear in mind that as a principal judicial organ of the United Nations, its task is the peaceful resolution of disputes. And any role that's been played by a judge in that process needs to be acknowledged. The second sort of consideration, which is very critical, that needs to be borne in mind in understanding the role of individual judges, is their particular vision of the role of a judge in the International Court of Justice. For the lack of time, I would say there are two possible alternative models out there, or alternative rather paradigms out there. One I would label the traditionalist paradigm, where in the vision of judge, there should be an economy of expression. A separate or dissenting opinion is written only when it is strongly felt that there are some issues that the court has not addressed or not addressed adequately. Now, and the second alternative vision is what I call the view of a vision of what I call the post-colonial deconstructionist judge. Now, the post-colonial judge from the third world or the global south also feels that in this process, it's important to challenge, traditional, which has usually favored favored Western nations. It is also important to contest some of the methodologies that are used. And in this model, the judgments are much more elaborate, and these judgments are used in order to challenge a particular Eurocentric vision of international law or vision of the global order. Now, both these models are equally legitimate, equally valid. But the point that I really wish to make it, that if you are in the traditional mold, then in order to understand your contribution, in particular, say, of an Indian judge, in this case, I have Judge Nagendra Singh in mind, then you have to read that individual's judgments and separate and dissenting opinions, along with his corpus of scholarly work, because the scholarly work does not directly enter the decision. Whereas in the second model, you may find your scholarly work more directly manifesting itself. An exemplar of this model is the late, very distinguished judge from Sri Lanka, Judge Christopher Veeramantri, who used his judgments to contest, the Eurocentric vision. So to conclude, it's in order to appreciate the individual opinions, you need to know the vision of that particular individual judge, and then look at his contribution likewise. Like I said, in the case of Judge Nagendra Singh, the longest serving judge from India on the International Court of Justice, president for 3 years, we need to look at his judgments, and I'll come to them later, along with his more than a dozen scholarly books on the most cutting edge areas of international law. And finally, of course, and I won't get into this because Ambassador Rajamony has already gestured toward this, we have to keep in mind the socialization and background of individual judges, and of course they're imbibing the civilizational spirit of the nation that they come from. In this case, it is India, and their commitment to the core values which are reflected in the directive principles. I think I'll stop there and maybe return later with specific details about the judgments of at least two of our distinguished judges, Judge Nagendra Singh, as well as the currently sitting distinguished judge, Judge Bhandari.
Thank you very much, Professor Chimni and Mr. Philippe Couvreur, for a fantastic beginning. Let me briefly outline some of the contours of the discussion we hope to have. Now, since the first half of the 20th century, international law has been a hope to transcend the maladies of pre-war situation to lead the world to peace and security. Depending upon how you want to assess it, that particular role in advancing the cause of international law has been to some extent achieved, but a lot needs to be done. No doubt the role of the International Court of Justice, the principal judicial organ of the United Nations, has performed in this evolutionary process is truly noteworthy. Since its first decision in the Corfu Channel case, the ICJ has played a huge role in the progressive development of international law as it settled the many disputes between states and provided advisory opinions to states and non-state actors, propelling society's advancement towards the much desired peace and security. In fact, even today, one of the things that is quite remarkable is the fact that nations do depose faith and trust in the ability of ICJ as an institution to be able to deliver the cause of international justice. Emphasizing this constitutive role of the ICJ, Professor Philippe Allott writes, and I quote, "Like any other social institution, a court is a transformatory structured system, transforming social reality in particular ways. Itself the product of the past social reality of a particular society, a court makes a specific contribution to the general social task of forming a given society's future out of that society's past as it acts in society's continuous present," unquote. Now, the source of imagination a court uses in order to discover and then actualize the general and particular social reality is the judges of the ICJ, by focusing on the legal relations among the states as guided by the fundamental principles of international law, secure and safeguard the social reality that forms the basis of international society. Now, of course, this particular role is not quite unique, even when you compare the domestic context. Increasingly, domestic institutions are also driven by those processes as well. While the judges of ICJ rise above their national identities to have a transnational perspective, their approaches to international law have been shaped by one or another influence. Such influences are not necessarily politically national, but are culturally national and intellectually national. The idea that international law does have numerous ways of knowing it, which is causal to the many perspectives of and approaches to international law, has been gaining somewhat of attraction lately. It is these type of influences of international lawyers and judges which make this panel particularly interesting. Since its inception in 1945, 4 Indian permanent judges have served the ICJ till date: Judge B.N. Rao, Justice R.S. Pathak, Justice Nagendra Singh, and Judge Dalveer Bhandari, which is in addition to the many ad hoc judges like Judge M.C. Chagla, Judge Jeevan Reddy, and Judge P.S. Rao. Our distinguished panelists, as you saw just a few minutes ago, will dwell deeper into their lives, works, and arguments in order to somewhat ascertain their approaches as they are reflected in the many judgments, including separate and dissenting opinions. With that brief introduction, let me begin this sort of interaction with our 2 distinguished panelists. Let me ask this question to Philip. Now, Philip, while the judges of the ICJ have a transnational perspective, thanks to the universal character and universalist telos of international law, do the decisions of the Indian judges, individually or collectively, reflect any values or ethos which form the foundations of what may be called an Indian approach to international law? Or alternatively, given the fact that after all, Indian legal system to a large extent is defined by the common law system and indeed common law approaches, that there is nothing so unique about that particular character, and it reflects the broader tradition of the common law legal system. Philip.
Thank you so much for this very interesting question. I would say that the answer to this question is, in my view, definitely yes. Let me start with the obvious. Judges are human beings, and as such are naturally influenced by their personal background. Their personal background includes many things. Of course, their individual legal training and culture, but also many other elements, sometimes even more fundamental, such as their, as we would say in Western philosophy, their human space-time, that is their anchorage in a particular place, in a particular time of history. And social environment, where you grew up, how you were educated, what were the values in your environment are, of course, extremely important, not only for judges, for everybody. So that is, of course, but natural. And that does not diminish the merits of those judges as high-level legal and judicial professionals. They, of course, all know that international law is unique, is universal, should not be influenced as such, technically at least, by national laws. But if there is a single international law, we all know that that single international law is perceived, understood, even applied through different cultural prisms. And that is exactly what is happening. And this is exactly why the drafters of the statute of the PCIJ, we will celebrate, by the way, the centenary of the statute of the PCIJ in December of this year, 16 December 1920. The drafters inserted in that statute a very important provision, Professor Chimni referred to it, Article 9 of the statute. I will quote it because I think it's important. Article 9 says the following: at every election to the court, the electors shall bear in mind not only that the persons to be elected should individually possess the qualifications required, and this is the important passage, but also that in the body as a whole, the representation of main forms of civilization and of the principal legal systems of the world should be assured. So this cultural prism through which international law, which is universal, the same for everybody, is apprehended, is recognized, and the statute of the court, Article 9, has passed unchanged to the 1944 statute, even requires that those prisms be represented in a balanced way on the bench. So far from singularizing international law, those prisms bring more universality into that law, because this single law again is apprehended differently on basis of the personality, the legal education, the values of everybody. This is recognized in the statute of the court. This is the richness, I would say, of the court, this variety of cultures and of ways of understanding a unique rule. And it is supplemented in the statute of the court by Article 39 on the languages. There are two official languages of the court. Ideally, there should be more to promote universality, but technically it would be probably difficult. But at least French and English were supposed in the 20s to represent and to express the leading legal systems of the times, the civil law for French and the common law for English. So coming back to your question, it is thus but natural that the Indian background, the Indian values that Indian judges bring with them be important in the court because they again constitute the prism through which that international law, common to everybody, will be apprehended, perceived, understood with all different nuances. And that is why the bench should be culturally balanced, because those different perceptions should finally meet and enrich each other so as to give to the court its real universal dimension. Now, more concretely, what are the concrete manifestations of that reality as far as Indian judges are concerned? Well, my personal experience is that they brought with them a particular personal and cultural profile, which finds its expression in the following examples. Indian judges, for example, have always been very professional and particularly respectful of the institution and of their colleagues. Indian judges have always, in my experience, expressed themselves with a lot of tact, elegance, and moderation. They have at all times been promoting consensus within the court. Professor Chimni was also referring to that a few moments ago. You cannot only understand the way of working or the thinking of a judge through possible opinions, but of course, the judge has an important task in the deliberations, in the preparation of the final decision. And there, the input of the Indian judges has been important. I don't enter into the substance now, but as a matter of style, I would say, they have always shown concern for consensus. And parenthesis, there was a reference made previously to opinions. Judge Singh, for example, as a judge, he's the only one who sat 16 years on the bench, never appended a dissenting opinion to any decision of the court. And neither did Judge Bhandari, although Judge Bhandari dissented on certain points of operative parts of judgments of the court. But he never used the terminology dissenting opinion. I think they have in common, and with other Indian judges, that sense of consensus and, working together and promoting also conviviality within the court. Then I think that Indian judges have been also very keen on promoting in proceedings before the court equality of arms and fairness between the parties. And they also have always insisted on negotiations. A case can be pending before the court. That does not prevent the parties to look for a peaceful settlement of the dispute otherwise, out of court, for example. The one does not exclude the other. Indian judges have always, I noticed, that favored the idea of negotiations in a kind of climate of amity between the parties. And then, as to their judicial thinking, I have noticed that it has invariably been marked by, of course, the respect for the rule of law. We will come back on that, but also on moral principles of humanity. It's very clear. It was very clear in the personality and the writings of Judge Singh, but it is also clear in the opinions of Judge Bhandari. And of course, their personality was so. They were and are very human people. So that principle of humanity and principle of natural justice is, I think, a common factor to all of them in their judicial thinking. I think I can stop here for this first question, and I think that probably my Indian colleague will, it will be easier for him to detect what in those observations, I would say,
Thank you.
what would be typical of the Indian culture?
Thank you very much, Philip. That was absolutely fantastic. You have used the word tactfulness, elegance, moderation, consensus, all of which are quite interesting. And let me move to Professor Chimni. Professor Chimni, Judge Nagendra Singh had, as we know, faith in the universality of international law and emphasized the need for its enforceability in domestic systems through the rule of law culture. Even in his non-judicial writings, he has traced his faith as bestowed by India's civilizational specialness as well. Now, is this sense of normativity of Judge Nagendra Singh typically Indian or Asian, especially when some of those positions are akin to Asian judges like, say, Judge Veeramantri? Is that uniquely Justice Nagendra Singh's own experience drawn out of democratic development, as well as an aspirational element of rule of law deeply embedded in Indian civic and political culture?
Yeah, thank you, Raj. Yes, very much so. I think his deep commitment to rule of law at the domestic level was carried forward to an equally deep commitment to international rule of law. I may mention that he probably combined within himself the best of Eastern and Western traditions. He, of course, was a Sanskrit scholar, if one may say so. On the other hand, he was also the student of perhaps one of the most distinguished judges of the 20th century, Sir Hersh Lauterpacht, with whose pupil he was in the 1930s in Cambridge. So he combined the best, and from both the traditions, he imbibed this strong commitment to the international rule of law. And this is reflected in his judgments as well. In one of the most prominent of his separate opinions, in a case called the Nicaragua case, which is a very celebrated case on the principle of non-intervention, he in fact not only stressed the importance of international rule of law, but more significantly stressed the importance of abiding by the foundational principles of international law that were embodied in the Charter of United Nations. And I'll read out a sentence or two from his opinion on the question of need to respect the principle of non-use of force, as well as the principle of non-intervention into the internal affairs of other states. Now, in his judgment in his opinion in the Nicaragua case, he said that the principle of non-use of force belongs to the realm of jus cogens, that it is a peremptory norm of international law from which there can be no exception. And he went on to say, and is the very cornerstone of the human effort to promote peace in the world torn by strife. This aspect does need to be emphasized. And then he again went on to say that the non-observance of the principle of non-use of force could lead to disastrous consequences, causing untold misery to humanity. So again, reiterating, stressing the importance of respecting the foundational principles of international law, and his commitment to peace, international rule of law, and international peace was also imbibed, from India's freedom struggle, Gandhiji's commitment to the cause of non-violence and peace. In other words, there are so many sources which come together, which coalesce as if it were in the work of Judge Nagendra Singh, and bring out probably the best of insights. Another if I may just take one more minute, another important opinion that he delivered was in the advisory opinion of what is known as the Western Sahara case, in which what was an issue was the application of the famous 1960 UN General Assembly resolution on decolonization. And he again underlined the importance of that resolution and its implementation, along with the need to take into account the opinion of the people. The latter is important. This showing his sensitiveness to democratic practices, to democratic structures. And so in combination with the respect for the foundational principles, I think these can be the two pillars of building a peaceful global order, relying on democratic structures on one hand and principle of non-use of force and non-intervention on the other.
Thank you very much, Professor Chimni. For all those viewers who are watching us, we are live on Facebook and YouTube. Very shortly, I'll be taking questions. And so please send in your questions and I will be asking those questions to our distinguished panelists. Let me move to Philippe. Philippe, it is notable in many of the decisions of Judge Nagendra Singh that he often espoused the historical approach, be that in reinforcing the erga omnes nature of the principle of sustainable development or the absoluteness of the principle of non-use of force, which Professor Chimni just highlighted. For example, in a separate opinion in the Nicaragua case, he criticized the court's over-reliance on treaty provisions to establish the universal character of the principle of non-use of force, ignoring the customary antecedents of the principle. Now, how do you situate this particular approach that Justice Nagendra Singh has adopted?
Well, I think we have again to go back to his personal background to understand his positions on all that. And maybe I can very shortly go back to Nagendra Singh and the rule of law, because before passing to customary law. Judge Singh and Professor Chimni reminded us that a few minutes ago, was not only a great internationalist, he was a learned Vedic scholar, and he was a very deeply religious man. I can testify that because we had long conversations and I'm so grateful to him. He opened my eyes to many things spiritually. And because of that, I think that he had a particular interest in traditional Indian values and spirituality. And that influenced, of course, his positions on the rule of law. First of all, he liked to recall that all the important rules of international law nowadays more or less existed at the Vedic age. Territorial sovereignty, the prohibition to occupy or to subdue an occupied territory, law of the sea, rights of coastal sovereign, the right of innocent passage, the right to ingress and egress ports, diplomatic law, immunities. The dutas had recognized immunities, and in ancient India, representatives from other countries, from other states, would be treated with full respect. And of course, the law of treaties. He liked to recall that the basic rules of pacta sunt servanda and rebus sic stantibus had their origin in the Indian traditions. Not to speak, of course, about eradication of war and promotion of peace, peaceful coexistence, and of course the Code of Manu and the law of war. For the first time, there is a strong distinction between combatants and non-combatants, and the prohibition of hyper-destructive weapons. These concepts precede, of course, in history, have been preceding for centuries the Geneva Convention of 1949. It's amazing. He liked to recall that he was proud of that, and I think rightly so, of course. And he would always keep that in mind. Another aspect is that, of course, he considered, and that you can find it in his books, or particularly in his book about international law in India, universality of law is very important for him. But again, as I said before, universality was not the denegation of particular, of cultural or spiritual particularisms, but the law was the same and had to be the same for everybody. I think that's also the Indian tradition. The Dharma is there, and I mean, it applies to everybody, including the king and the armed might of the state. So for him, the rule of law was, Judge Sir Robert Jennings said once, he had belief in the rule of law and he was devoted to it, and that was exactly so. For him, it was something immanent as well, belonging to his roots, to his beliefs, and universality was important, and implementation and effectiveness of the rule of law was very important for him too. I'm not going to come back on Nicaragua, United States for the time being, but now coming back to your question about history, I already explained, I think, why, in my opinion, Judge Singh liked to go back to history, because it was part of himself. It was part of his education. Again, he had a lot of respect for Indian traditional values. And, well, all the Indian judges at the court had that, but the difference was that he was born in 1914 and he entered Indian civil service in 1937. So that means that he was already very active when independence was proclaimed. And he had to live his whole life, also because of his training, with this duality, this pre-independence and post-independence periods, with his deep Indian roots and his British legal training. And, well, maybe that has sharpened his interest, this British legal training has sharpened his interest in Indian history and Indian legal traditions. And maybe that would explain why he very keenly would go back to those aspects, to history and to custom, because it is said, my Indian colleagues are far better qualified than me to say that, but it is generally said that the Hindu law is a collection of human practices and customs based on principles of morality and justice, and also on social consent. That means that it is a kind of law which is the product of society, not of political power, like the statutes, the law, and the treaties at the end of the day. So for me, there is nothing strange, ultimately, that he was interested by customary law, and that he so strongly defended the autonomy of customary international law vis-a-vis treaty law in the Nicaragua case. But he did it generally. He was interested and attached to custom. I think that's, I could
Thank you very much.
Here.
Thank you very much, Philip. Professor Chimni, let's quickly move on to another person whom many people in India may not even be aware that he had a distinguished presence at the ICJ. I'm speaking about Judge B.N. the first Indian judge to ICJ. He's, of course, more known in the Indian circles for his outstanding contribution to the Constituent Assembly of India, the famous conversation that Judge B.N. had with Justice Felix Frankfurter of the US Supreme Court. That, of course, is part of the larger Indian imagination. He's, of course, known for his constitutional temperament and faith by which he viewed constitution as a means and tools to fulfill the goals and aspirations of a society. Now, how do you think that this mindset reflected and even shaped his role as an international judge?
I think it shaped his views in a very critical way, because we all know of his enormous pioneering contribution to India's constitution making. And he's the one who traversed the world and met with principal figures, as you mentioned, Judge Frankfurter. And so he was able to bring the insights of the domestic constitutional law tradition bear upon international law issues. But like I mentioned at the outset, many judges do not have separate opinions to their credit. As far as, to the best of my knowledge, he authored with 3 or 4 other fellow judges one major dissenting opinion. But I have absolutely no doubt that he would have contributed greatly in the internal deliberations of the court in arriving at its decisions. I may also mention that, and I may be wrong here, but to the best of my recollection, he also met with the great American professor and judge Philip Jessup, and they had a very important conversation, and I believe some of those reflections have found their way into the Indian Constitution. But if I may take the opportunity, just to complete the picture on Judge Nagendra Singh, I think it wouldn't be appropriate if we did not mention that his first book, which I think was his doctoral thesis, was a pioneering work on nuclear weapons and international law. And I think it was the first full-fledged study of its kind, in which, of course, he took the position that nuclear weapons were unlawful. And later we know that in the 1996 advisory opinion, which the International Court of Justice delivered on the lawfulness of the threat or use of nuclear weapons, Judge Veeramantri, who was on the dissenting side, this was one of those difficult decisions. I think it was a 7-7 divide with the president voting. In his dissenting opinion, Judge Veeramantri actually cited an entire passage from Judge Nagendra Singh's book in order to support his understanding that the threat of use of nuclear weapons could not be justified under international law. This is important also because it shows the respect fellow judges had for both his opinions as well as his scholarly work. I'll stop there and perhaps elaborate on other matters later.
Thank you, Professor Chimni, for that. Let me move to Philip. Philip, of the 4 Indian permanent judges to the ICJ, 2 were, as we know, justices in the Supreme Court of India, and 2 were civil servants. All of them engaged deeply with the national system in their respective roles as judges and civil servants, espousing certain values and a sense of professionalism. Is there anything marked about this particular background of theirs in their roles as judges of the World Court?
Well, this is a very interesting and very delicate question because, of course, as I said before, I've been privileged to know 3 of them. And of course, they were very similar, bringing to the court their Indian values and culture, but also different, and worked slightly differently. But was that due to the fact that some of them had been already judges before and others were rather civil servants, or was that due to their personal history? And it is very difficult to be assertive on that. But I would like to make 2 observations. It's difficult to compare, of course, Judge Patak, because Judge Patak only served 2 years on the bench. He took part in one single advisory opinion. He was very active, by the way, I remember very well. He was very interested and very active, but it's not sufficient to answer your question. So to try to answer that question, I think I have to focus mainly on Judge Nagendra Singh and Judge Bhandari. Well, first of all, something what I note is that, I said before, because probably of that culture of consensus, none of them ever appended a formal dissenting opinion. Judge Nagendra Singh, in his opinions, has a tendency, but it was his personality, he was like that, the tendency is almost never to criticize the court. It's rather to put the decision of the court in what he would have thought to be the right perspective, and then try to substantiate and try to reinforce the decision of the court, being loyal to the institution. And he himself said very often, but he wrote it as well, that the role of the court, in his book, for example, on the role and records of the ICJ, he said the role of the court is to impart universality, but also clarity, precision, esteem, elegance to the rule of law. And it is precisely, I think, what he was doing when he was drafting an opinion. Judge Bhandari is also, of course, somebody who is very much devoted to consensus. He's a very easygoing person, very nice, and always trying to achieve agreement within the court. And he had 5 separate opinions and 2 declarations. None of the opinions, declaration cannot, but none of the opinions is entitled dissenting opinion. But he was dissenting. He was dissenting, first of all, in the Ukraine-Russia provisional measures phase. There, the court considered that Ukraine had not substantiated its case for plausible rights under the International Convention for the Suppression of the Financement of Terrorism. And Judge Bhandari voted against that, not in the operative part, because the operative part did not deal with that convention, but he said very clearly, I consider that the Ukraine made its case on that. That was clearly dissenting. Same thing in the whaling case. The court decided that, I'm not going to enter into technical details, but that Japan, with its program, JAPA 2, had respected Article 30 of the schedule to the Whaling Convention. And Judge Bhandari disagreed with that and said, in my opinion, Japan did formally respect schedule, Article 30 of the schedule, but in substance, it didn't. And that article was dealing with the relations between state parties and the Whaling Commission, and in particular, the transmission ahead of the implementation of the permits, the whaling permits delivered by the states. And Judge Bhandari went even further than that, and he said the court concluded that JAPA 2 was not a scientific program, but I say it was a commercial program, and the court should have said that. See. In the Nicaragua-Colombia case on alleged violations of certain sovereign rights, Colombia had raised a preliminary objection saying that that case was tantamount to try to ask the court to enforce itself the previous 2012 judgment on the merits. And therefore, Judge Bandari, although the court considered that Nicaragua was fully entitled to bring a case about alleged violations of its rights as defined by the court in 2012, Judge Bandari considered with Colombia that that was in fact tantamount to request the court to itself enter into the implementation of its own judgment. And for Judge Bandari, that was inadmissible. So he voted against that point of, although his overall opinion, or it was a declaration, the declaration, of course, is not dissenting, could not be, because opinions have titles, but not declarations. But also in the genocide case, Judge Bandari voted there with the court and appended a separate opinion, but he questioned finally the way the court had approached the analysis of the dolus specialis, in particular in relation with the events in Vukovar, where there had been massive bombardments on civilian populations. And the court had decided that that was a message to punish the Croat people, and that that was not an intent to destroy the group as such. Judge Bandari could not accept that and said the distinction between motivation and intent is not clear, and the court should have followed the new developments, in particular in the case law of criminal courts, the recent case law of those courts. And so you see, while being for consensus, and he's of course always in the way he does it, he's always so moderate and so kind. But entitling his opinions separate, still he dissented. And I was wondering whether this distinction between Judge Singh and Judge Bandari was not due, at least partially, to the fact that Judge Bandari had been trained and so accustomed to render individual judgments in which he would express his own opinion in a very firm way. And he's very well known for that. Everybody knows his judgments on food grains or on night shelters in India. Probably there, it was said of Judge Singh that he was incarnating the symbiosis between diplomacy and adjudication, and probably there the difference, but it is simply an hypothesis. It is too early, I think, to really try to conclude on that. But the professional background before the court could be an explanation for the difference in style, at least. And I would see a second one. As you said before, Judge Singh lagged very much in his opinions, but also in deliberations and conversations in the court, to refer to not only to history, but to philosophy, to religion. He was rather constantly, even when applying law, referring to meta-juridical or meta-legal considerations. And that is something Judge Bandari so far has not been doing. Probably, but again, I'm not sure, because he is more used to that very judicial discipline to deal only with strict law. I stop here. They have, of course, many things in common. Again, they have things which distinguish them. They were not born at the same time. They have not the same personal background. But these differences could maybe also be explained by their previous judicial training or civil servant training. Thank you.
Thank you so much, Philip. That was an extraordinary, reflection, but also a beautiful case of judicial ethnography that you, articulated. Listen, we could go on and on, but we are coming to the end of this program. I'm going to take a couple of questions. There's a question for Professor Chimni. This is from Abhilasha Ramakrishnan. And this question is that, does there need to be a fail-safe measure put in place to ensure that the decisions of the ICJ are enforced so as to prevent a reliance on the Security Council to ensure compliance, in the sense to avoid another incident similar to Nicaragua versus the United States? Professor Chimni.
My colleague would have been, Philip would have been in a better position to respond to that question. But my sense is that that most of the countries party to the International Court of Justice's compulsory jurisdiction, or who have in one mode or another approached the court, tend to abide by the decision, of the court. And we must accept that in a sovereign state system, in the Westphalian system, there are limits to enforcement of measures against sovereign nation states. So my sense is that, like with in the instance of other international law regimes, a heavy reliance has to be placed on the good faith of states to abide by international law. But in the final analysis, there is a great sentence from Hans Morgenthau's Politics Among Nations, which said that there is the iron law of politics, that international law obligations always yield to national interests. So when it comes to absolutely critical national interests, the sense is international law will give away. And one should not place too much store or emphasize that too much, because in a large number of cases, nations fulfill their obligations.
Thank you very much, Professor Chimni. Mr. Philip, there's one question which is, I suppose, a number of people are asking a similar question, and I'll quickly ask you that. This is about to what extent, judges who come from different jurisdictions, to a large extent, are appointed, or at least the process that leads to their appointment is driven by governments and government agencies back from their own countries. To what extent that process shapes and even informs their ability and their, let's say, functioning as a judge? In some ways, the real question that some people are asking is that, to what extent the judge, not just Indian judges, but also judges in general, are able to exercise their judicial role somewhat independent of the fact that they, after all, are coming through a nationally evolved process in which their respective governments have played a role in selection and nominating them?
Well, that is a very interesting question too. I would say that, of course, we all know how nowadays elections are carried out. We know that there are political interests, that there are pressures, that there are lobbyings, etc. But I think that once an individual has become a judge, this is quite different. The candidates are by definition very high-level candidates always, and they know that the basic feature, the basic duty for a judge to be credible, and it is a question of duty as well, is to be independent and is to be impartial. And they have to pronounce a solemn declaration when taking office in that sense. So they know that whether they be influenced by their background, we said a lot about that. I'm sure that even unconsciously, they are influenced by their background, by what they are. And it's normal. We've seen it. It's normal. It's natural, after all. But I don't think that any judge would not be, that there would be a risk that the judge would not be independent because his or other governments would have sponsored his or her candidature. I don't think so. My experience is that really these are, again, very high-level professionals. There are people also of very high moral level, and they can perfectly make the difference between a campaign and then the exercise of their duties on the bench. And to come back, if I may, very quickly to the previous question, it's very important to stress that only 3 judgments of the court have not been implemented, but have been implemented with some difficulties. The Nicaragua United States case has been implemented, but it took some years. The monetary gold, the famous monetary gold case, has been implemented after decades, but it was. And the same thing is valid for the Nicaragua-Colombia judgment. I think that states also are adults. They know what their duties are. And even if they have most of the time internal political difficulties with the judgment, at the end of the day, in the few cases in which it is not immediate, they will comply with the judgment. It is reassuring, and compliance is not only a responsibility of the Security Council. That's very important to say. It's a responsibility of the whole international community. All states have to remind those who would not comply that it is their duty and they are responsible under international law. Thank you.
Thank you very much. We have, of course, run out of time. I want to take this opportunity to thank Professor Chimni and our distinguished guest, Mr. Philippe Couvreur, who served as registrar of the ICJ, and of course the Indian Embassy in the Netherlands, and Ambassador Rajamony, for this fascinating discussion that we've had today. We couldn't have got a better group of people to reflect about the role of Indian judges and the International Court of Justice at The Hague. For all the viewers, including students and faculty of Jindal, but also other law schools and others who have been watching this program, it's an absolute treat. We have, of course, the recorded version of it, which will be available in our YouTube channel as well. For my closing remarks, I want to quickly say that I'm grateful to Ambassador Rajamony and also the Indian Embassy staff at the Indian Embassy in Netherlands. Also my colleagues, Professor Srijit, the Executive Dean of Jindal Global Law School, and Abhilasha, and many other colleagues who contributed to the discussion and preparing for the session. With those words, I would request Ambassador Rajamony if he has any final thoughts. Otherwise, we will say goodbye to all of you.
Thank you, Dr. RajKumar. Can you hear me?
Yes, please go ahead.
Yeah. Thank you, Dr. RajKumar. I entirely agree with you that it has been a wonderful discussion, and we could not have had better panelists who have truly provided insight into the functioning of the International Court of Justice, as well as the contributions made by Indian judges. So we have started off in a wonderful way, and now we move on to the other webinars that we are planning. The next one being with the President of the International Court of Justice and the Registrar and Judge Bhandari on October 19th. In the meantime, thank you very much, Philip. Thank you, Professor Chimni.
Thank you very much for you.
Thank you.
And I hope all the viewers enjoyed this discussion. And
thank you very much.
Thank you very much.
Dr. RajKumar.
Thank you. This program has ended. Thank you.
Thank you. Thank you very much.